An Arizona father lost all parenting time with his daughter. He didn't lose because of confirmed abuse. He lost because of 27 words he sent at 2:17 in the morning. Today I'm breaking down the case, the pattern, and the custody mistake you cannot afford to make against a high-conflict ex. Family court is not criminal court. The standard is not beyond a reasonable doubt. It's the best interests of the child. And that standard is won through documentation. Judges see dozens of these cases a year. The parent who shows up with a dated, coherent record often wins, even when the other parent is louder or more sympathetic in the hallway. The case is in re-termination of parental rights as to the child. Arizona Court of Appeals decided the 27th of February, 2024. Public record. I'll stay close to it. Married 2010, divorced 2016. The child was born 2013. The dissolution gave mother sole legal decision-making after the court found father had committed domestic violence during the marriage. Father got alternate weekends and holidays. By 2017, the child started having behavioral difficulties, tantrums, defiance, aggression at school. Mother took her to therapist Deanna Vance. Diagnosis: adjustment disorder with anxiety. Mother reported the child was scared of visits to father after he moved out of town. Then, in early 2019, the child reported father punched her. School reported to DCS. DCS investigated and unsubstantiated the allegation. But custody consequences didn't stop. Mother filed for suspended parenting time. Court issued a temporary order, cut off father's in-person contact, ordered a family evaluation by Sidney Buckman. Buckman observed supervised visits. The child sat in father's lap for 45 minutes, played blocks, looked happy, but he noted father had an explosive temper and recommended parenting classes. Then the bite incident. The child bit father during a visit. Father bit back on her shoulder. Mother photographed the mark, took the child to a pediatrician. DCS substantiated the bite. Father was indicted on child abuse. He entered a deferred prosecution program to keep the child from testifying. He has consistently denied biting her. From May 2019 forward, father had zero parenting time. Court ordered reunification therapy with Ann Claw. First joint session seemed promising. Father showed the child photos of a pet fish he kept for her. Later sessions, the child said she didn't want to visit father until she was in college. She told her therapist she just wanted to be dead. Mother later sought to terminate father's parental rights entirely. The juvenile court denied her petition. Father appealed the termination denial. I want to be careful here. Diagnosis belongs to clinicians, not YouTube channels. But there is a documented litigation pattern that shows up repeatedly in high-conflict custody cases. 1. Provoke the other parent. Texts, emails, in-person triggers. 2. When they react, memorialize it. Film it, screenshot it. Turn emotion into evidence. 3. Present that reaction to the court as proof the other parent is unstable. It's called moving the goalposts. The goal isn't resolution. The goal is to make you respond, then turn your response into Exhibit A. Here's what saved father in this case. He kept showing up, within the court's rules. The Court of Appeals noted these facts. He completed individual counseling. He completed parenting classes. He consistently sent cards and gifts, even when envelopes were returned. When birthday gifts were burned in the backyard by the mother's partner, he opened a bank account for the child, so she would inherit the money at 18. The appellate court ruled mother failed to prove by clear and convincing evidence that termination was in the child's best interests. The court specifically cited father's rehabilitation efforts and his willingness to separate his feelings toward mother from his parenting role. The order was affirmed, meaning the lower court's refusal to terminate father's rights stood. That doesn't mean he got custody back immediately. It means the law still views preserving the parent-child relationship as a powerful interest, even after 5 years of no contact. 3 mistakes that hand the court to a high-conflict ex. 1. Reacting to every provocation. Your emotional response becomes part of the record. 2. Deleting messages. Courts view spoliation as consciousness of guilt. 3. Retaliating with your own accusation without evidence. False equivalence destroys credibility. Instead, save everything. Use a co-parenting app even if the other parent refuses. File motions with exhibits attached. Request a guardian ad litem when patterns are clear. And when the court orders services, counseling, parenting classes, reunification, complete them regardless of how unfair the process feels. That record is your best insurance. If you're in this situation, I put together a one-page checklist of the evidence categories family court judges weight most heavily. It's in the description. Save this video, share it with someone who needs it, and subscribe because your story deserves to be told accurately. I'll see you in the next case.